Well, good morning, everyone. Welcome to this Evershed Sutherland PROPcast. My name's Joe Keen. I'm a professional support lawyer to the real estate practice here at Evershed Sutherland. I'm going to be joined in a moment by Claire Gregory and Catherine Manning, who are a partner and principal associate in our environment, health and safety team. Now, our subject today is sold with information, and that's a well-known term that we see in all manner of real estate transactions, but of course, particularly where land is being sold for development. Now, this all centers around potential contamination of land. So just bringing in Claire and Catherine, maybe you could just both introduce yourselves and give us a quick summary of the sort of work that you're involved in.
Sure. Hi, good morning, everyone. My name is Claire Gregory and I lead the environmental team here at Eversheds. Obviously, we cover all aspects of transactional support, so the detail that we're going to go through today, but we also do a lot of environmental litigation, so usually Defence of Environment Agency prosecutions and plenty of general advisory work, which I'm sure Catherine can talk about.
Yep. So yeah, obviously as well as that, and advising on contaminated land, we advise on a lot of specific kind of waste issues, chemical compliance, which is REACH, biocides, classification, labelling, and packaging. We do both from an EU perspective and equally from a UK perspective. Reducer responsibility, so packaging, waste electrical and electronic equipment, ROS, the restriction on hazardous substances in electrical equipment, and also kind of water related issues. So yeah, we cover a pretty wide range of things, but yeah, today we're going to focus obviously in on some of the specific rules around contaminated land and sold with information.
Absolutely, we are. So my first question, really to set the scene and before we get into the specifics of sold with information as a bit of a concept, could you give us a little bit of an introduction to the contaminated land regime, please?
Sure, no problem. So I think the first point to emphasise is that liability for cleaning up contamination under the regime, that's the contaminated land regime set out under Part 2A of the Environmental Protection Act 1990, it does only arise in certain limited circumstances. So for the regime to apply, the property itself must meet the definition of contaminated land. There's quite a high threshold to meet, so it essentially means that significant harm is being caused, or there's a significant possibility of such harm to the environment or human health, or again, the significant pollution of controlled waters, like surface water, groundwater, that's being caused, or again, there's significant possibility of such harm, and harm is assessed by reference to the land's current use.
And I think just here we really want to kind of emphasize the fact that just because there might be hazardous substances on a site, kind of hotspots of contamination, it doesn't necessarily mean that the site is going to meet the definition for contaminated land for the purpose of the regime. And for a site to meet the definition, there must be a source of pollution, a pathway, and a receptor, which is something that can be harmed by that pollution. And that would include humans. And it really is quite seriously contaminated land that we're talking about here. It's not just kind of, something where there's a little bit of a hotspot somewhere. It's really an unacceptable risk to human health or the environment, and that's what you're looking for in order for it to meet the definition.
In terms of how the regime is policed, so local authorities have a statutory duty to inspect their areas to identify contaminated land. I don't think it's massively being pushed because of funding, but there is that duty there. If contamination is found, then the local authority, or in some circumstances, the Environment Agency, must then serve a remediation notice on the appropriate person. We'll come up to what that means a bit further on. Unless those persons are willing to carry out remediation on a voluntary basis, which is usually where most of these sites end up. It ends up being done on a voluntary basis rather than through a statutory notice. So I mentioned before, appropriate person. So the regime has this concept of who is the appropriate person to clean up, i.e. who can be served with a remediation notice. And I'm sure many of you listening will be familiar with the basic principle of the polluter pays. The idea that if your actions or activities have caused contamination, then you will be responsible for remediation. However, I guess in many respects, this is a massive oversimplification of the regime. If contamination requires remediation, the regulator will look to the Class A person. So Class A people are those who cause or knowingly permit pollution. And a knowing permitter can be someone who, say, for example, buys a site, is aware of contamination, that obviously has the power to do something about it, but doesn't take that action. So again, sort of an innocent owner potentially. It's quite difficult to apply this concept in practice. Knowingly permitted is not defined in the legislation itself, and there's no additional guidance in the statutory guidance that sits alongside the regime. In the previous guidance issued in 2006, which is now obsolete, it did state that for a person to knowingly permit contamination, they must have known about it and had the power to do something about it. I think this is reflected in case law in relation to other regimes that use the same wording as well. But essentially, this means that the person must have had the ability to take steps to prevent or reasonably remove the contamination and had reasonable opportunity to do so. There has been very little case law on it in terms of Part 2A, and it will all come down to what the party actually knew at the time.
And I suspect really the rationale behind this is if someone is aware of contamination on a site and simply sat by and did nothing and allowed the situation to get worse, effectively they're as at fault or as culpable potentially as the original cause of that contamination. And I think that's why the regime has this idea of both the original causer and also a knowing permitter who's, allowed that situation to continue or to develop, and that they equally can both be part of that Class A group.
And then I guess moving on to kind of the next bit is if no Class A person, so no polluter, can be found, the regulator will then look to Class B persons. The whole aim of the regime is to ensure that there are no orphan sites, i.e. sites that end up the responsibility of the taxpayer. So here they will look to the current owner or occupier of the site, so a wholly innocent owner of property that may not know anything about the contamination at all.
So the regime's clear on who can be liable. However, there is often this confusion around the fact that an innocent owner or occupier can be made culpable and can be liable for cleanup under the regime, whether we do apply this principle of the polluter pays, and that's kind of a key facet of English law. But yeah, so polluter pays, but sometimes it can be an innocent owner or occupier can also pay.
Well, I think that's the sort of the thing that's could give a bit of concern to someone who's coming in buying a site. Maybe they just acquired it and they're looking at potential liability. And I dare say that's the sort of place where you both get heavily involved with providing your advice, and then where somebody is perhaps going to find themselves on the hook for contamination, but maybe they didn't cause it.
Exactly, yeah. So innocent owners or occupiers, they can be liable. However, it's really important to remember that that liability only arises where the original polluter or another knowing permitter can't be found. So it's kind of that backup liability, that person who's on the hook if no one else can be found in those circumstances. So taking the next step, so having identified the appropriate person and people, the regulator then has to work out the contamination that's present that requires cleanup, and for each contaminant, identify who are those appropriate people and apportion responsibility between those people. And as you can imagine, if you've got a site with a very long industrial history, with lots of potential contaminants on the site, lots of different people have done lots of different activities and different things on that site, it can be a very complex and time-consuming task to work out who exactly is responsible for each individual contaminant linkage. And that may be one of the reasons why there have been very few designations of land as contaminated land. So to sum up, the basic principle is the polluter pays, that if you buy a site and you have knowledge of a serious issue, you may well be seen as a knowing permitter and effectively potentially as culpable as the original causer. And even if you have no knowledge of a problem, you could become liable as an owner or occupier of the site if it's designated and nobody else can be found.
And going back to kind of what Catherine said before, when you're dealing with these complex sites with long industrial histories, it is unlikely in practice that one person will ever be solely responsible for all the cleanup, because the regulator has to consider each pollutant linkage. So each type of contaminant found, each pathway, each receptor, and work out who is going to be liable in relation to that particular issue. And they have to do this. This is part of what the statutory guidance says. So in theory, it is possible that a Class B person could pick up all the liability, but it is more common on a site where there would have been many former occupiers that at least some of them are still around.
Okay, well, thanks very much for that sort of summary and that background. Then let's really get into the main subject of the PROPcast, which of course is sold with information. At a basic level, what is sold for information and how does that work?
The sold with information is just one of the ways through which a seller of land can try to transfer its Class A liability. So that's if it's liability as a polluter, i.e. a causer or knowing permitter, when the land is sold. The process is set out in the statutory guidance, which accompanies the legislation, the Part 2A regime. And the purpose of it is to exclude from liability those who, despite being a polluter, a Class A person, have disposed of that land in circumstances where it's reasonable that someone else who has acquired the land should bear liability for remediation. So sold with information applies in two situations. The first one is in express drafting in documents that the seller of land has provided information about site condition to a buyer, and therefore the buyer will have taken this into account in setting its price, and it has therefore been reasonable that the buyer then picks up the liability. If this has been agreed between the parties, there will usually be an acknowledgement of this in the sale contract. And where you are selling a site and you have environmental reports, it's also important that these are listed in the contract to demonstrate that the property has been sold with the information and what that information is. Secondly, there's also, under the regime, there's a deemed sold with information provision, which will apply automatically where the buyer is a large commercial organisation or a public body and has had permission from the seller to carry out its own investigations. And this is whether those investigations were actually carried out or not. If you were given the opportunity to do so, then this trigger kicks in. So the effect of this is that even if a contract is silent on environmental liability, if you're buying land and you've had that permission to carry out investigations, it's likely that you will be deemed to be buying with knowledge of the site's condition and trigger the sale with information provisions.
So that's, I suppose, the risk from a sort of buyer position. Thinking about it more from a seller perspective, how effective is this regime? And is it a sure thing, or is there an element of risk and flexibility with it?
So yeah, I think if is it effective, it does really mean on what you mean by effective. It only applies in certain circumstances, and a buyer can always try to argue that it doesn't apply, and trying to rely on deemed sold with information, that is particularly risky. And the key limitation on when this will or won't apply is where the buyer, in order for it to apply, the buyer also has to be a member of that Class A group. And if it's not met the requirements to be a Class A person in its own right, it won't work. And a key point to remember is that if you've received information for the purposes of sold with information, the sold with information test, that doesn't necessarily mean that you've had sufficient knowledge or the opportunity to clean up to make you a knowing permitter. So if you're buying land in these circumstances, you're not going to be the causer because you haven't originally caused the pollution. So the only way you can get into that Class A category is if you become a knowing permitter. So if you don't have enough information, you haven't had enough time to do cleanup, if it's not suitable, it may be that you never become a Class A person. And whether or not you become a Class A person or a Class B person, that's decided at the time of the determination of the assessment of contaminated land. So it's not at the time of sale, it's whenever it happens later when the site is designated. And equally, in order for sold with information to apply, the sale has to take place at arm's length. So that means on terms which could be expected on a sale in the open market between a willing buyer and a willing seller. And if there's a group of transactions or there's a wider agreement, it's taken to be at arm's length if the net effect of the group transaction or agreement as a whole is a sale at arm's length. So it kind of takes into account the whole situation and circumstances of the sale. Equally, for it to work, it's only treated as a sale for the purposes of this test if it's a transfer of land of a freehold transfer, or there's a grant or assignment of a long lease of more than 21 years. And before that sale became binding, the buyer must have had information that would reasonably allow that particular person to be aware of the presence on the land of the contaminant identified in the relevant contaminant linkage, which the regulator is considering at that point, and the broad measure of that presence, and the seller didn't do anything to misrepresent the implications of that presence. So it does all take into account the specific circumstances that have gone on as part of that sale and what information was available to the buyer, what they knew about, what the seller told them, and yeah, so it takes into account all of those things. And equally, for it to work, after the date of the sale, the seller can't retain any interest in the land or any rights to occupy that land. So if there's kind of a sale and a leaseback situation, that then gets tricky because the seller has retained an interest. That provision, it excludes kind of minor interests. So if you've got kind of a benefit of restrictive covenant, that won't count and mean that the sale doesn't, the sold information doesn't work. And then I think one thing just to draw your attention to, both Claire and I have been saying trying to transfer liability, because even if you include provisions in the contract, there are circumstances where it just doesn't work and liability can revert back to the seller. And an expression that you should always have in the back of your mind is once a polluter, always a polluter. So if you're concerned that your own activities have caused contamination on a site, or you're aware of contamination and know that it should be cleaned up, the only way that you can be absolutely certain of not facing a liability in future is if you clean up that contamination before you sell the site.
That's quite a big decision there. I mean, you mentioned how the sold information regime applies with it was the transfer of freehold, a grant or assignment of a long lease. So does that mean then that if you've got a shorter lease, you just have to sort of work your way up the chain of ownership to find that person who's got the greatest interest to maybe for the liability to attach to?
It really depends on the specific case, and it can be quite a convoluted process. I'll try and set it out in relatively simple terms. So essentially, the regulator must first make this initial identification of persons who may be responsible in respect of each contamination linkage. So first, it's got to determine who is the Class A liability group. It might be there's one person, it might be a group of people, and then or the Class B liability group for each pollutant linkage, and that's contaminant, pathway, receptor. It may be that an occupier under a short lease is the causer of the pollution, in which case it may be relatively simple for the regulator to determine liability, and the regulator would not have to work up the chain of ownership. In other cases, the regulator may have to consider the current position and work out who holds what interests. It may also have to trace back through the historic ownership and occupation of the site to try and find out who was the original causer or knowing permitter. It will then have to consider whether there are any orphan linkages, i.e. pollution caused by people that they can't find or are no longer around, have gone into insolvency. That's where there's no Class A or Class B person. And then the regulator needs to decide what remediation was appropriate for each linkage and attribute responsibility between each liability group. So how responsible for the cleanup should be apportioned between each linkage and each liability group. It is very complex. And then once they've done this, they need to determine whether any members of that Class A or Class B group should be excluded. So this is the point at which the regulator would consider the concept of sold with information and whether that test has been satisfied, amongst other things. And then it will determine how the liability should be apportioned between different members of those liability groups. For example, there may be 2 or more Class A persons in respect of a particular linkage. So the person who originally caused it And then there might be another person who bought the site, knew of it, didn't do anything about it and allowed it to remain. So here the regulator would then determine their respective responsibilities.
And it can be very complicated and drawn out. And it can take a considerable amount of time for the regulator to determine liability, and then that determination may be contested. So it can take a huge amount of time for a designation of contaminated land and for any liability to actually materialise.
Okay, great. Well, let's move away then from the, I suppose, the legal effects. Could you tell us a little bit about how sold with information is viewed and gets used in the market?
Yeah, of course. So I think generally buyers and sellers have both become a lot more comfortable with the contaminated land regime and the risks it represents. However, I think there is still quite a lot of confusion, particularly around with the principle of sold with information and deemed sold with information. And sometimes it may be that a silent contract is the best position, given this principle of deemed sold with information. But parties often will prefer to have express drafting because that's, as lawyers, generally, that's what most of us prefer. We like to see it written down very clearly. We can see it. It makes sense to us. But as time has gone by, I think people have got familiar with some of the principles of contaminated land and have become a bit more flexible in their thinking and what they're willing to accept on certain transactions. I suppose let's consider the situation where you're buying, selling land, contract doesn't contain any specific environmental provisions. In this case, a seller will be relying on deemed sold of information. And then the effect of that is that even if it is silent, if you're buying land and you've had permission to carry out investigations, the likelihood is you will buy with that knowledge. There are occasions when a seller might be willing to rely on that, but often that's where we think effectively the seller is very unlikely to have any liability itself once it's sold the site. So often people are willing to rely on deemed sold with information where there's a very low risk of them ever being determined to be a Class A person anyway. And if a seller is concerned that they might actually have a liability, it is quite risky to rely on deemed sold with information in those provisions because there is nothing to stop a buyer at a later date trying to argue that it doesn't apply. And that they didn't have enough information, that they weren't actually aware of the issue. And equally, it might be that they sell the land on very quickly after they've received it. And it might be that they never actually become a knowing committer in their own right. So it never works. And because there's very little case law around this, there is a risk that if there ever was a case on it and it's taken to court, it may go against you on the day. And so for that reason, many sellers don't like to rely on deemed sold with information, and they do want to include specific drafting because that does maximise the chances that it will work, and it tends to that tends to be the default is that express drafting.
Yeah, I mean, I think going back to what Kat just said, as lawyers, we're risk averse and we like to include the wording in there. We like it to be clear. I think another point that comes up in line with that is whether the seller asks for an indemnity up front that sits alongside the sold with information provisions, because a regulator, it would be very unusual for them not to follow the Part 2A regime, but they don't have to apply it. So I think where you are acting for a seller, and we have done, if the deal will withstand it, it's always good to get an indemnity to support that sale with information provision as well. In some cases, this can be achieved, often where the seller's provided environmental information to the buyer, which the buyer can then rely on, perhaps by way of reliance letter or collateral warranty. However, there are other cases where in requesting indemnity, the result can be to frighten off the buyer. And this may also result in a request for a counter indemnity. This can result in a bit of a compromise, which may be a worse position for a seller than had the seller not requested the indemnity in the first place. So while we do see these coming up, there has been no movement towards their presence or absence being standard. I think it really depends on the transaction and the strength of bargaining power for each particular party. I think this is why it's also worth considering including terms regarding contamination in the heads of term. often we find that transactions progress far more smoothly where a particular position has been agreed up front. You know, if you're trying to get an indemnity kind of shoehorned into an agreement midway through negotiations, it's not really a good place to be. But if it's been agreed up front, it's then very difficult to persuade a buyer or seller to accept something else. So the experience of the regime has led to more parties and their agents having these discussions early on in deals, which is really helpful for us, and it certainly avoids the parties getting entrenched later and inevitably incurring more costs.
And then I suppose the final point is just to think about is environmental insurance that may be suitable for certain sites. Sometimes it may cover a risk that someone's concerned about. Generally, you'll need some environmental data to get it, so at least a phase one. And there are likely to be kind of quite big exclusions from that policy. And the key one is it won't generally cover cleanup costs on redevelopment, so that if you're redeveloping a site, you're not going to be able to get insurance to cover that risk of the costs to clean up as part of your planning permission.
So I suppose a key point of where that bit of market practice we've just talked about there and the commercial side of things, and it meets with the legal, is going to be how all of this gets dealt with in the courts. But you said there's not much case law out there in terms of some of these key bits of sold with information. Where those items have come before the courts, what's that shown us from that sort of the approach that the courts are taking towards the regime?
I think you're right, Joe. There have been very few cases on contaminated land regime, which is surprising since it's been enforced for 25 years now. And you know, and it was brought in with quite high profile. There have been some cases which have established some important principles and have explained how the regime works in practice, though. I think Catherine can
Yeah, so I think something that's clear is that it can take a long time for contaminated land liabilities to materialise. And it takes a long time from designation of the site as contaminated land to a remediation notice being served. And then it can also take a long time for it to get to court if it does get to court or if it's settled. Key is also the contaminated land regime is complex. The rules around apportionment of liability between different parties is complicated. And given the potentially significant liabilities involved, parties are likely to try and minimise that liability. So they will try and argue any possible point to reduce that liability. And where there's a change in legal entity, in terms of ownership of a site, there's no guarantee that that entity will be treated as a Class A person. When you're dealing with liabilities, you have to be particularly careful where there's transfers between different entities, and particularly statutory transfers. So, for example, when there's been nationalisation of industries, or there's been privatisation of industries, or there's been transfer of statutory functions from one body to another, you have to kind of track through and be careful as to whether that liability is passed or not. But very clear language is needed in order to transfer contaminated land liabilities to an entity that wasn't in existence at the time. And then another key point is you do have to follow that statutory guidance.
Yeah, we're coming towards the end of the PROPcast now, so I'm going to skip and look a bit forward. I suppose, what do you foresee in terms of changes to the regime, both perhaps in terms of maybe the legislative framework, but also how it might operate in practice?
We think the regime is very likely to become more topical again, particularly given the risks that are being identified now in respect of PFAS. It's becoming ever more prevalent, and 5 years ago we weren't really testing for it, but as most of you listening will know, once you look for it, you tend to find it. Some people may remember when the regime originally came into force and there was a huge amount of concern around it. However, I think over time, people have got more comfortable with the risks and how it operates, particularly given that there have been relatively few designations by the regulator today. Sometimes it's almost viewed as a theoretical risk. I mean, the main push of the regime itself was to ensure that land was cleaned up, ideally on a voluntary basis. So perhaps it's achieved its aim to some extent. But there have been around just over 1,000 designations, which, given that there are estimated to be 350,000 contaminated sites in the UK, is really very few. I think it may well become more of a contentious issue again due to things like PFAS, because it's very expensive to clean up. There aren't set methods of cleaning up yet. So there'll be much more of a push on people to resist liability. And we might start to see the regime being implemented more to ensure that that remediation is dealt with.
Well, thank you very much. And that brings us to the end of this PROPcast. So a really big thank you to Claire and Catherine for sharing all of their knowledge and their expertise with us. And to everyone out there, thank you for listening.